It's up to us to learn it, understand it, and apply it.
Cause being broke is just a state of mind.
Keep taking pages apart. That's capital, baby. That's capital.
Credit is an asset. I'm finna show you why it's an asset.
When we get up in the habits of buying assets, our assets pay for our expenses.
These are just various checks I've gotten in 12 months for one house.
It's a mindset. We change the way we think.
Cause
I'm
being
just,
broke is
talking
just a
about the
state of
stuff I heard.
mind.
This is stuff I'm actually out here doing.
The credit world is going to change for you because now you're empowered with information and strategies to achieve whatever it is you try to accomplish.
I am a resource. I know y'all. Y'all know me. Reach out to me.
Oh, that's great. That's great.
Yeah, you know what time it is. Disclaimer, I am not an attorney, nor do I offer or give legal advice. So please understand that all information that we talk about in any of my webinars are strictly information and educational purposes. And most of it is just personal experiences with things anyway. So please understand this is not legal advice. And may you be blessed on your journey to find your power within these laws. Peace and blessings. Now, let's look at debt discharge through the eyes of the Uniform Commercial Code. 3-311, accord and satisfaction by use of instrument. If a person against whom a claim is asserted proves that that person in good faith tendered an instrument to the claimant as full satisfaction of the claim, the amount of the claim was unliquidated or subject to a bona fide dispute. Unliquidated or subject to a bona fide dispute. And the claimant obtained payment of the instrument, the following subsections apply. B, unless subsection C applies, the claim is discharged if the person against whom the claim is asserted proves that the instrument or accompanying written communication contained a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim. That's some pretty intense words right there. But what does this mean? Can we see this in action to see that this is real and what this can do to a claim? Certainly. We're going to stop there. Let's look at case law. I already have one pulled up right here. Save time. Here we go. This is September 30th, 1992. The Burke Company is the plaintiff. Hilton Developed Company is the defendant. All right, this is in Florida. Judge's name, you can look this up for yourself in your free time. The defendant has moved for dismissal of the plaintiff's complaint for lack of subject matter jurisdiction over this diversity action, or alternatively, for summary judgment based on the common law doctrine of accord and satisfaction. The plaintiff argues in response that it has met the requisite amount in controversy, and further that under Florida law there has been no accord and satisfaction. Although the court finds that the plaintiff has satisfied the amount in controversy required of 28 U.S.C. 1332, it nonetheless concludes that as a matter of law, there has been an accord and satisfaction, and therefore summary judgment is appropriate. All right, finding of the facts. Now, let's just stop right there and just go over what we just took in. Now, they had a disagreement or dispute. They went and conversated, had a discussion. A check was given with a restrictive endorsement. It was cashed. Then, 30 days later, another check was given and it was cashed. But before they cashed it, the receiver tried to X out the restrictive endorsement and then still cash the check. That's exactly what he did. Tried to call and tell him he was doing it. Then when they figured it out, they said, hey, you need to send us that check back. But it was too late. They had already cashed it. They wasn't trying to send that check back. Well, let's see what happens next. Let's scroll down here. Conclusion of law. A motion to dismiss. A motion to dismiss for lack of subject matter jurisdiction based on a plaintiff's failure to satisfy the amount in controversy requirement of 28 U.S.C. 1332 should not be granted unless the defendant shows to a legal certainty that the claim is really for less than the jurisdictional amount. There's some case law at citing. I strongly suggest you check those out as well. The amount in controversy requirement is met if the plaintiff has made a bona fide allegation that his claim is in excess of $50,000. Here go more case law. Based on a careful review of the record in the present case, the court finds that the plaintiff has made a bona fide allegation of its claim and that the defendant has not met his burden under the legal certainty standard. The defendant's motion, therefore, is denied. All right, B. Motion for summary judgment. All right, now to save for time, I'm not going to read all of this. I'm going to get straight to the gusto right here. In the present case, the defendant has raised the defense of accord and satisfaction, claiming that the plaintiff's acceptance and negotiation of its check designated a full final settlement of all sums owed to the payee by the payor on the Holiday Inn Job 57 constituted a release by the plaintiff of any rights it may have had under the parties' prior lease agreement. The plaintiff counters by arguing that Florida Statute 671.207 abrogates the common law doctrine of accord and satisfaction and instead provides a mechanism whereby a creditor can negotiate a debtor's full payment check and at the same time preserve its rights to payment or right to payment under the former agreement. The positive question for consideration by the court is whether Section 67.1.207 supersedes the common law doctrine of accord and satisfaction. For the reason that follow, the court concludes that it does not, and that the parties' transactions is governed instead by Florida's law of contract, which, although inconsistent on this issue, arguably supports a finding on accord and satisfaction as a matter of law. So, here you have it. Accord and satisfaction is a matter of law. If you have a bona fide dispute with someone and you tender them payment with a restrictive endorsement stating the intent of this payment in full accord and satisfaction and they cash it, they just allowed you to change the terms of the contract or the original agreement. What can you do with that? Could you do that with a mortgage? Could you do that with a car note? Could you do that on a credit card debt? Case law supports it. Would you invoke it? It's accord and satisfaction. Well, I choose to invoke my rights. So here we go. Now, I know most of you are familiar about the reconveyance of my property. If you're not familiar, just go ahead and check my YouTube. There's a video. We talk about it there. I'm not going to go there here. But here's another one we're doing accord and satisfaction with. Now, this is the servicer for the new mortgage on my other property. And we sent them their payment, right? Here it is. Memo section. You have the restrictive endorsement. Payment in full satisfaction made on the condition that the obligation be canceled. Loan number right there. Redeeming lawful money and demand at the U.S. Treasury Department of the United States and the City of Washington, D.C. or any federal bank. Okay. That's the front. I left the number blank on this one so you could actually see. Here's the date. February this year, $28,000 in conjunction with that $789. All right. Now, let's look at the backside of the endorsement. Let's see. Where is it? All right. Boom. There we go. All right. Now on the backside, we have by acknowledgement and endorsement of this draft, the payee acknowledges full and final settlement of all sums owed to the payee by payor on account number 316965. All right, we got that on both of them. Now, let's see if they cashed the check. If you remember from the first one, that check number ended in 0416. All right, when you look up that postal money order number, boom, post office box, the amount, view status, money order for that amount has been cashed. They were sent together, so understand they both have been cashed. So they accepted the new agreement of the terms and condition of the contract. Because prior to them receiving this money order from me, I sent them a bona fide dispute. In that bona fide dispute, it was for settlement. And I also asked them to send me an address of where they want me to send this money to, so I can tender it in full, accord and satisfaction with the restrictive endorsement. Now, they got 90 days to either send me my money back or they accepted the terms of the new contract. So they need to release any liens they have against my property. And we have yet to see what's going on because they still got a few more days left. So by the end of May, April, by the end of next month, we should have some new. Another way to discharge a debt. Accord and satisfaction.